Hi, I'm Gina Johnston.
And I'm Thomas McFarlane.
In this video, we're going to look at prescription and limitation. The rules of time bar or limitation are of pivotal importance to practitioners and clients in every jurisdiction. Most jurisdictions have legal and procedural rules in place which set time limits on the raising of causes of action in order to prevent stale claims. Rules of limitation or time bar are in essence rules of public policy which seek to strike a balance between the interests of the pursuer and giving them enough time to make a claim and the rights of the defender and not having the threat of a potential claim hanging over their heads indefinitely. There are also practical issues with stale claims. Evidence will often become less reliable and more difficult to secure as time passes, and witness recollections may become poorer and less reliable. If a pursuer does not bring a claim in sufficient time, they may find that they have lost the ability to pursue it. Importantly, for those more familiar with English law, the rules in relation to time bar in Scotland are different to those in England and Wales.
In Scotland, the law governing prescription and limitation is set out in the Prescription and Limitation Scotland Act 1973, as amended by the Prescription Scotland Act 2018. For ease of reference, we'll refer to the legislation as the 1973 Act. The 1973 Act applies to all claims where the underlying obligation is governed by the law of Scotland. The first thing to mention is that there is a distinction between prescription and limitation. Prescription has the effect of completely extinguishing a right or obligation after a period of time has passed, and this is a substantive matter of Scots law and is applicable wherever litigated. Limitation, on the other hand, does not extinguish rights or obligations, but introduces a procedural bar on raising legal proceedings. Collectively, these are often referred to as time bar in Scotland. As with most other jurisdictions, and for obvious reasons, time bar is a frequent source of dispute and litigation in Scotland. In fact, time bar has been an even hotter topic in Scotland since 2014, following a landmark decision of the Supreme Court in the case of ICL Plastics, and this overturned around 30 years of what was understood to be settled law. This is what led to the amendment to the 1973 Act by the Prescription Scotland Act 2018, which sought to deal with some of what were seen as particularly harsh consequences on pursuers as a result of the Supreme Court's clarification of the law. A number of these key changes to the law of prescription came into force on the 1st of June 2022. In this section, we'll focus on the law following the changes enacted by the 2018 Act amendments. We'll look at the main time bar periods, what is required to stop the time bar clock ticking, and we'll also look at standstill agreements.
The relevant time periods vary depending on the nature of claim or right. For a claim to pay money or compensation on contract or delict, referred to as tort in England, the prescriptive period is 5 years from the date of breach of contract or breach of duty, subject to certain rules as to when the clock starts ticking. In England and Wales, this is 6 years. We also do not have the same concept of primary and secondary limitation as there is in England and Wales. For certain claims relating to property, the prescriptive period is 20 years. For personal injury actions, claims are limited after a period of 3 years. Any time period during which a pursuer is of non-age, that is to say they're under 16 years of age, or under legal disability by reason of unsoundness of mind, is not counted. For claims of defamation, the period is 3 years. For claims of harassment, the period is 3 years. For product liability claims, the period is 10 years. For a claim to make a contribution between joint wrongdoers, the period is 2 years. The 2-year period generally begins when a party is found liable by a court or where they commit to a settlement where it considers that a third party should also contribute. Under the 1973 Act, for the 5-year time bar period to begin, the pursuer must also be able to satisfy what is known as the discoverability test. This was introduced with the 2018 Act amendments and has 3 strands. The pursuer must be aware, firstly, that loss, injury or damage has occurred. Secondly, that the loss, injury or damage was caused by a person's act or omission. And thirdly, they must be aware of the identity of that person. Whether a pursuer is aware that the act or omission that caused the loss, injury or damage is actionable in law will remain entirely irrelevant to the triggering of the time bar period. There are some limited circumstances in which the clock may start ticking at a later stage. Section 11.3 of the 1973 Act is often relied upon by creditors seeking to delay the time bar clock. The 5-year period is frozen during any period that the creditor was induced to refrain from making a relevant claim by reason of fraud on the part of the debtor or any person acting on his behalf, or error induced by the words or conduct of the debtor or any person acting on his behalf. This does not include any time period after which the creditor could, with reasonable diligence, have discovered the fraud or error.
So what has to be done to stop the time bar clock? Broadly speaking, there are 3 methods to stop the clock: a relevant claim, a relevant acknowledgement, or a standstill agreement. Although a standstill agreement really extends the time bar period rather than stopping it. Taking each of these in turn, the first is to stop the clock by the party making a relevant claim, or what we as litigators may refer to as judicial interruption. This means they have to validly serve proceedings on the defender. An important point to bear in mind in Scotland is that it's the date of formal service of the court action on the defender that stops the clock, not lodging the action in court, as is the case in some jurisdictions. A pursuer could therefore find themselves in difficulty if they are up against a time bar deadline and they have issues validly serving on a defender. For example, if an individual has changed address without them knowing.
The second method to stop the clock is a relevant acknowledgement of the claim by the defender. Section 10 of the 1973 Act provides that it must satisfy one or either of the following conditions. A, that there has been such performance by or on behalf of the debtor towards implement of the obligation as clearly indicates that the obligation still subsists, or B, that there has been made by or on behalf of the debtor to the creditor or his agent an unequivocal written admission, clearly acknowledging that the obligation still subsists. The crucial point there is that the admission must be in writing. The most common form of relevant acknowledgement of an obligation seen in practice is ongoing performance, and typically that takes the form of an ongoing payment towards a debt or obligation. Whether or not there has been a relevant acknowledgement can be a significant point of contention, in particular whether a certain statement is sufficient to constitute an unequivocal written admission under the 1973 Act. Accordingly, parties should be very careful when responding to claims. In our video on Without Prejudice, Thomas notes that parties may use without prejudice wording in correspondence, but it's important to bear in mind that this will not necessarily protect the writer. There have been cases where, although a party has used the phrase without prejudice, they have nevertheless still been found to have made an unequivocal written admission under the 1973 Act. The third method to stop or really to extend the clock, which was introduced by the 2018 Act, is a standstill agreement.
On the 1st of June 2022, standstill agreements were made permissible in Scotland by Section 13 of the Prescription Scotland Act 2018. However, parties are not given free rein and there are a number of restrictions. Standstill agreements are only available once the prescriptive period has started to run, for a maximum period of 1 year, and only one extension will be permitted. Standstills are not available for all types of claim, and they are only available in claims under Section 6 and Section 8 of the 1973 Act. Section 6 relates to the 5-year time bar period, and in general terms this applies to obligations to pay a sum of money and other contractual obligations, obligations to pay compensation, as well as breach of contract and negligence claims. Section 8 relates to the 2-year time bar period for compensation claims between joint wrongdoers. However, generally speaking, the ability to use standstill agreements at all is a welcome change, as previously extending the prescriptive period was prohibited. Ultimately, the approach taken to standstill agreements should be one of balancing risk. They can be used as tools to extend the prescriptive period by 1 year, allowing negotiations between parties to continue, and this is beneficial in that it may avoid the need for costly litigation outlays and may help to maintain a better environment for cooperative discussions to resolve the dispute. However, they can also create uncertainty, and a successful challenge to the validity of an agreement could render a right to a claim being lost. Those entering into standstill agreements should therefore be aware of the risks involved and to ensure that standstill agreements are drafted carefully to minimise these risks. We hope you found this video on prescription and limitation of interest. If you have a dispute on which you require legal advice, then please do get in touch.